Okay, let's take a couple minutes to discuss a public trial. I put in a simple question. I was listening to the news, and I listen to a lot about court cases, and uh, courtrooms being closed to the public. Okay, so the public has a fundamental right to attend most criminal trials guaranteed by the First Amendment, ensures transparency, accountability in the justice system, allowing citizens and the press to observe court proceedings while open. The right is not absolute and may be restricted by some judges for reasons such as safety or witnesses, privacy, constitutional basis. The Supreme Court, Richmond Newspaper Inc. versus Virginia, recognized that the First Amendment implies to the right to attend trials. Additionally, the Sixth Amendment guarantees a public trial for the defendant. What is open? Public access generally includes jury selection, preliminary hearings, and the trial itself. Restrictions: trials may be closed if there is an overriding interest, such as protecting witnesses, e.g., sex offense cases or minor victims, preventing jury contamination or limited seating capacity. Limitations: while you can attend in person, this right does not generally exceed to the use of cameras. Cameras are already audio equipment in federal courts, which I find highly objectionable, because how can the public, if there isn't room, should have access to see what's going on in that courtroom, and to deny you that right is if, as I told you, it's rare. I've never seen a judge or a lawyer play by or enforce the rules of professional conduct and the court of judicial conduct in a court of law. So I got kicked out of quite a few courtrooms, chased out of them for taking the rules and the codes and expressing to defendants their constitutional rights to effective assistance of counsel, and I would make every attempt to describe that to them by pointing, having the rules of professional conduct and the code of judicial conduct with me and pointing them out to them. And these are the legal obligations of all lawyers and judges. I used to say that at the very top. And I've had people make questions about probable cause hearing, a quick and speedy trial. One guy, I don't know what happened. I got chased out, but they spent 6-7 months trying to convince him to take a plea deal. When I started talking to him, I said, tell him about a quick and speedy trial. There's limitations on that, and they exceeded it, so the judge should dismiss it with prejudice. Just mention, that they violated your right to a quick and speedy trial. And guilty or not, dude, I don't know, but all I can tell you is they broke the law. I'm guessing your attorney kept saying, sign this and you can go. Sign this and we'll drop it. And nothing will happen. And you're like, well, what's going on? And, and state's attorney's threatening you. If you don't take the plea deal, they're going to throw more charges at you, which is illegal. But either way, I got chased out. Some lawyers accused me of practicing law, and I accused them of not practicing law. I had the rules and the codes to prove it. So, I'm not a lawyer. I didn't go to law school. I've just read a lot of books and an abundance of law books, and I started that in high school. And but you'll want to see that the public has a right to see a trial. Like I said, unless it's minors and essay offenses and that's what I used to do. So can anyone just walk up to a courthouse and watch a random jury trial? I did. I tried a couple of times. Back in the 80s, I used to bounce in and out between different courts. I got chased out of this one court one too many times. It wasn't a big court, but the judge got mad at me for trying to cite my constitutional rights, and I was arrested, and I was demanding probable cause hearing, and he told me I didn't understand how the process works, and then I started citing the rules of professional conduct about communication, candid towards the tribunal, being diligent and expediting this litigation, simply because there's a lack of probable cause. State's attorney, according to Rule 3.8, special responsibilities of prosecutors not to bring forth a case that they cannot, give probable cause. And I asked for it to be dismissed with prejudice, and the judge was mad, but they dropped it, and I got chased out of there because people were asking me, "What the heck did you say?" And but all you need is the rules of professional conduct and the code of judicial conduct. The last kid I helped help him get his case tossed. Public defender didn't like me mentioning, probable cause hearing, talking to the kid about the rules of professional conduct, not inside the courtroom, but inside the court, the hallway. It was at 51st and Wentworth. And public defender, here, just sign this and you can go. I said, I told you, kid, defective, destructive assistance of counsel. He said, excuse me? I says, yeah, what's the ground rules for effective assistance of counsel? Excuse me? I says, there's no excuse for violating the rules of professional conduct. The kid said, yeah, so how come you said this? He said, well, listen, this is what the judge wants. He said, what about a probable cause here? The judge don't like that. And so he went and talked to the judge and the state's attorney. They made the kid go last. Courtroom was empty. The lawyers, the judge, the kid, and me. And the judge started yelling at me. What are you doing here? Sixth Amendment of the U.S. Constitution, you also find in there the right to effective assistance of counsel. So there's a different thing you can get a case tossed out on, as I've been trying to teach you in my other videos. But there was a controversy I was listening to about people not being allowed to view a trial, and there was no specific set as to why. But there's no actual reason to deny the public access to a trial. So yes, the public has a fundamental right to attend most criminal trials guaranteed by the First Amendment. Okay, if there's any reason, be sure to ask. Well, because the judge said, well, the judge has to have some reasoning. I mean, in order to see that everything goes according to the way it's supposed to start, and you'll find that in the Rules of Professional Conduct and the Code of Judicial Conduct, all right? That's deprivation of rights, okay? Because they took the oath to do that. The oath, what's behind the oath, what lawyers and judges got to do, their job description is the Rules of Professional Conduct, Code of Judicial Conduct, and that rarely happens. And so that's you'll always have their neck in a noose if you take that with. If you don't, then you're destined to get screwed. I'm just trying to be direct and honest. I was using AI, but the analytics from some of these websites I posted on said that I start losing people after a couple of minutes, and that's because I don't explain any of this stuff or read more of it. So remember, I've always found interest in going to courts. I got chased out on civil cases. I was interested in divorce court, and I gave a couple. Started with the woman; they were getting divorced, and her woman was pissed off at one end of the hallway. Her soon-to-be ex was on the other side of the hallway, and the lawyers were all somewhere talking. They're giggling and laughing and joking, and so I guess the woman thought I was trying to get some digits, or a number or something, but I wasn't. I was just asking her if she knew exactly what was going on, and she gave me enough time where I talked to her. Does she know her lawyer's job descriptions and the limitations, this should have been done over long ago. She said, what do you mean? She says, his lawyer didn't give my lawyer this and that. We're waiting. And I said, no, that's failure to expedite litigation. You know, it would be diligent to expedite that litigation. It would be competent. She goes, yeah, I know. I says, you know how many laws that is that they broke so far? She said, what are you talking about? I said, this is the rule of professional conduct, and these are your lawyer's duties to you, and he's not doing them. I said, did they communicate? Look at right here. Did anybody communicate this to you? She said, no, and then she started reading the mandatories for communication. That didn't happen. I said, well, right now, is anybody being diligent? So she read the particulars for diligence, and that's not happening. You know, I says, expediting litigation, you know, that failure to do that is basically breaking the law. That is, you know, this is your constitutional right. You know, a failure to do this is deprivation of rights right here. And she just looked at me, you're kidding me. Why would I kid you? I'm literally holding the law and trying to give it to you. Here, read it for yourself. And I said, is that your husband? She says, yeah, here's a copy. Give one to him. I used to carry around, I used to make 10 copies and go to court and just try to talk to people. That was back in the 80s. And when I was going through a divorce, there was a lot of things I was trying to figure out. And I met a kindly judge who used to talk to me. And we met a few times. And basically all was said and done, I didn't have a chance. And it's quite depressing having a judge confess to you that due process doesn't exist. So if you want, number one, you should learn the rules of professional conduct, code of judicial conduct. Just print it out like I did. I went to the library, had it on both sides, so that way it's half the expense, which was a couple of bucks to have it printed out. Then I went over to Staples, I think it was, and had it put it in a binder. My own little personal book to carry around. It's about 35, 40 pages long at the most. And then with every issue I have, I highlight it, and this is what I go to court and talk to the lawyers and the judges about. And I did the same thing with the Code of Judicial Conduct. But if I wasn't handicapped, that's what stopped me from going to the courts. I don't know, 50-something. And I was ready to get chased out again. All right, but there was an issue about a public trial, and most people don't believe me, you know, or didn't believe me about the right to a public trial. And I think we should make every trial public for everybody, so that everybody knows that all lawyers and judges are playing by the rules of professional conduct and the Code of Judicial Conduct. That's how everything's supposed to start. It didn't, so whatever you're going through right now should be null and void. Especially with the quick and speedy trial. Anybody could get out of whatever they're in if they were denied that. Just look up a quick and speedy trial. It's rare that those obligations are fulfilled, and you can have a case dismissed with prejudice. And don't forget to mention ineffective assistance of counsel, prosecutorial misconduct, and judicial misconduct, because it's a duty of everybody in that courtroom to fulfill the necessaries of a quick and speedy trial. That's not just up to your attorney. That's up to the state's attorney as well, and the judge as well. In fairness to the opposing party, it would be necessary to report any misconduct. You know, reporting misconduct is mandatory. So your lawyer not bringing it up, the state's attorney not bringing it up, the judge not bringing it up, is deprivation of rights. And considering the fact that nobody brought it up and nobody was charged for, for misconduct, and nobody was charged for failure to report misconduct, created a conspiracy against rights under the color of law, which is forbidden by federal law. Okay, thank you, and good night, people. I hope I made that make sense for you. You know, there's a lot of videos I do, and it's just, my videos, most of them are just on a particular legal term, and then when I talk, you see I threw a whole bunch of legal terms together. So it's not that hard to understand once you understand each legal term, and then you just put these words together, and that's how you make it make sense. Somebody called my methods rudimentary. Well, I just stick to the simplistics, the law. I don't try to muck it up with words you don't understand. I just read it word for word to the letter. In violations of the letter of the law, fines, removal from public service, and incarceration. Any attempt to violate the letter of the law is disinformation, and the penalties for disinformation are the same. Fines, removal from public service, and incarceration. All right. Thank you and good night. May your Creator always be with you and rain many blessings. I wish you a long life and good health. Good night.